Hello and welcome to MD's iLaw channel. In this video, we are diving into part 3 of our detailed AIBE 17 paper explanation series. 21st question is: an advocate may, while practicing, take up teaching of law in any educational institution which is affiliated to a university, so long as the hours during which he is so engaged in the teaching of law do not exceed -hours in a day. The correct option is B, 3. As per the Rule 3 of the Advocates' Right to Take Up Law Teaching, Rules, 1979. Permitted activity: advocates are allowed to teach law in educational institutions affiliated with universities. Time restriction: the teaching hours must not exceed 3 hours in a day. Overrides other rules: this rule takes precedence over any contrary provisions in the rules of professional conduct and etiquette, explicitly allowing advocates to engage in part-time law teaching. Objective: this rule ensures that advocates can contribute to legal education without compromising their primary professional duties and responsibilities to their clients. 22nd question is: in which of the following landmark cases the advocate was held guilty of professional misconduct as he had forged the court order? The correct option is A. Pratap Narain v. Y.P. Raheja. Handing over of forged documents to the opposite party case. Facts: the complainant alleged that the respondent handed him a forged stay order while no such order was actually passed by the court. The respondent claimed the forged order was given by his clerk. Held: the disciplinary committee, after examining the evidence, held the advocate guilty of forging the court order. As a result, the committee ordered the removal of the advocate's name from the role maintained by the Bar Council of Delhi, signifying a severe penalty for the serious nature of the misconduct. 23rd question is: suppose road accident occurs, then being an advocate, what is the correct way of approaching the situation? The correct option is A. FIR next petition then summon to insurance company. First step FIR, first information report. The first step is to lodge an FIR with the police to document the road accident. This ensures that the incident is officially recorded, which is crucial for any legal proceedings that follow. Second step petition. After the FIR is lodged, a petition can be filed, usually in a Motor Accident Claims Tribunal, MACT, for compensation. The petition will outline the details of the accident, the injuries sustained, and the compensation sought. Final step: summon to insurance company. The insurance company is then summoned to respond to the petition. The insurance company of the vehicle involved in the accident is typically responsible for covering the compensation claimed. This sequence ensures that the legal process is properly initiated and that all parties involved are notified and given the opportunity to respond. 24th question is: the principle of ubi zus ibi idem remedium was recognized in. The correct option is C. Ashby vs. White. This principle meaning is where there is a right, there is a remedy, and it was recognized and applied by the court in this case. Facts: Ashby, a qualified voter, was prevented from voting in a parliamentary election by the constable, Mr. White. Ashby sued White for damages, asserting his right to vote. White argued that Ashby had no remedy, since he did not suffer any loss or injury, and that the election result was not affected by his exclusion. Held: Ashby had a right to sue White for the breach of his right, even if he did not suffer any actual damage. The court said that, wherever a man has a right, then the party injured shall have an action against the wrongdoer. 25th question: Gloucester Grammar School case is a landmark case based on which of the following maxim? The correct option is A. Damnum sine injuria. This is a Latin legal maxim that literally means damage without injury. It refers to a situation where a person suffers some loss or harm, but no legal right of that person is violated. In such a case, the person cannot claim any compensation or relief from the person who caused the loss or harm. B. Injuria sine damnum, violation of a legal right without causing any actual harm or loss. C. Volenti non fit injuria. No injury is done to one who consents. A person cannot claim damages for harm they willingly accepted. D. Audi alterum partem, here the other side. The principle that both parties in a dispute must be given an opportunity to present their case. 26th question is: the National Consumer Disputes Redressal Commission under Consumer Protection Act, 2019 shall have the jurisdiction to complaints where the value of the goods or services paid as consideration exceeds rupees dash. The correct option is B, 10 crores. Under the Consumer Protection Act, 2019, the National Consumer Disputes Redressal Commission, NCDRC, has jurisdiction to entertain complaints where the value of the goods or services paid as consideration exceeds 10 crore rupees. This is provided under Section 58, 1A, I of the Consumer Protection Act, 2019, which states: Section 58. Jurisdiction of National Commission. 1. Subject to the other provisions of this Act, the National Commission shall have jurisdiction, to entertain, complaints where the value of the goods or services paid as consideration exceeds 10 crore rupees. 27th question is, under Section 41 of Consumer Protection Act, 2019 an appeal from the order of District Commission lies to. The correct option is A, State Commission. Under Section 41 of Consumer Protection Act, 2019, any person aggrieved by an order made by the District Commission may prefer an appeal against such order to the State Commission on the grounds of facts or law within a period of 45 days from the date of the order. The State Commission has the power to hear and dispose of the appeals against the orders of any District Commission within its jurisdiction. Note, there is no consumer tribunal under the Act. The National Commission hears appeals against the orders of the State Commission, and the High Court is not involved in the consumer disputes redressal mechanism under the Act. 28th question is, for an individual to be deemed to be resident in India in any previous year, one of the condition is. The correct option is A, if he is in India for a period of 182 days or more during the previous year. Under the Indian Income Tax Act, 1961, an individual is considered a resident in India in any previous year if they satisfy one of the following conditions. 1. They are in India for a period of 182 days or more during the previous year, or 2. They are in India for a period of 60 days or more during the previous year and for a total of 365 days or more during the 4 years preceding the previous year. Do you know why 182 days? The 182-day rule ensures that an individual spends a significant portion of the year in India, justifying the classification as a resident for tax purposes. This period is more than half the days in a year, indicating substantial presence and likely economic ties to India. If an individual is physically present in India for 182 days or more during the previous financial year, that is April 1st to March 31st, they qualify as a resident for that year. 29th question is, Mr. Kapoor purchased a residential house in January 2021 for rupees 80 lakhs. He sold the house in April 2022 for rupees 94 lakhs. In this case, the gain of rupees 14 lakhs arising on account of sale of residential house will be charged to tax under which of the following head? The correct option is A, income from capital gains. This is because the gain arising from the sale of a residential house is considered as a capital asset under Section 2(14) of the Income Tax Act, 1961. Capital gains are computed by deducting the cost of acquisition and the cost of improvement from the full value of consideration received or accruing as a result of the transfer of the capital asset. Capital gains arise when a capital asset is sold at a price higher than its purchase price. The gain of rupees 14 lakhs from the sale of this house qualifies as a capital gain. Since the house was held for less than 24 months, this would typically be classified as a short-term capital gain, STCG. 30th question. A person who has ultimate control over the affairs of the factory under Factories Act, 1948 is called as. The correct option is A, occupier. According to Section 2 of N of the Factories Act, 1948, the occupier of a factory is the person who has ultimate control over the affairs of the factory. This definition applies to any person who owns or manages the factory, whether it is a firm, an association of individuals, or a company. The occupier is responsible for ensuring the health, safety and welfare of the workers in the factory, and for complying with the provisions of the Act and the rules made thereunder. The occupier may delegate some of his duties to a manager, but he cannot absolve himself of the ultimate responsibility and liability. We have covered 10 questions in this video. the AIBE previous paper series, we will cover the remaining questions and old papers as well. If you like this explanation, please like the video and share this video to AIBE aspirants. Do not forget to comment below about the video and please subscribe to MD's Law channel, the legal classroom where every case is clear. Thanks for watching and keep watching our other videos as well for better understanding of legal concepts. See you soon. Bye.